Is it also possible to run everything off that computer up there?
Mm-hmm.
Hey, Nancy, nice to see you. Good to see you. We'll talk after.
Yes.
One of the ladies came and introduced me to herself. Oh, yes, so it's next to her. Okay. Yes. We'll talk after. Good. So do they already, they interact and toggle between? Oh. Kevin. Thank you. So it's a real pleasure to be here. Is the volume and everything okay for everyone in the back? Yeah? Okay. But, you know, we're here on Valentine's night together, and so I can't let that opportunity slip by without at least acknowledging a Valentine for all of you. Now, I had to give it deep thought about what kind of heart was appropriate for this group. Did I hit the mark? And for those of you in the room that are also chemists, here's your Valentine. Okay, now that we have that out of the way, I'll make a confession that for a few of you in the audience that know me well will know what my first love is. And my first love is polymers. It's what I fell in love with first, and that seems an appropriate confession on Valentine's Day. But my second love, here we go, patents. We won't even go down the path of where I get to be patenting polymers. That's just like overload, even on Valentine's Day. But we're here to talk tonight about patents. And when I think about patents, there are so many things that we can talk about, from searching patents to, you know, find relevant parties that have patents on compounds or ideas that you're thinking about, to this whole concept of broad patent claims, narrow patent claims, patent prosecution process, and putting that all in the context of branded drugs versus generic drugs in the pharmaceutical industry. It's a lot to undertake, and this doesn't even touch on everything that we could talk about in the patent area. But tonight, I want to talk about these topics, and we have a couple ways to proceed here. We could just sort of do it rotely and talk about each one. That would bore me to tears and probably you to tears as well. So what we'll do is put it in the context of, if I can get that to change, a case study. Our case study tonight that I'm going to use to illustrate all of these things is this little product here, Restasis. I'm going to just fiddle with this because it's not in sync with what's going on behind me, and it's a little awkward. Let me just see if I can get this to respond. Okay. Anyone know this product, Restasis? Yeah, we've got at least Kevin here. So Restasis is a prescription product by Allergan for treating dry eye, given twice a day. It's a very simple formulation of cyclosporin at 0.05 weight % in the formulation. And then this mix of ingredients that are listed here: glycerin, castor oil, polysorbate, a copolymer. See, got my love in here as well as water and sodium hydroxide. Why did I choose cyclosporin? It's a nice case study for a couple reasons. One is the active agent itself, cyclosporin. Structure is shown here for those of you that have to know, like I usually want to know the structure. I imagine there's some of you in here that want to know as well. So it's a compound isolated from fungus. In fact, it's a compound that was on patent, and this is the original patent issued in 1978 to Sandoz, long expired. This patent expired in 1995. So we have a current relevant product on the market where the compound is long off patent. That's a nice case study to figure out, you know, how do you go about protecting a new product coming on the market when the compound is already known, off patent, and its activity as of an anti-inflammatory is also known. So that's one of the reasons that I chose the Restasis product. The other reason is, yeah, it's been a really big product. I've highlighted here a little blurb that I found online that in the fourth quarter of 2016 alone, the sales of Restasis were, what is that, $393 million. So we're talking about $1 billion a year over the last couple years for this compound alone, or for this Restasis product alone. So it's interesting from that perspective because it has been truly a blockbuster product for Allergan. Now the other reason that I chose this is this little ditty here, the St. Regis Mohawk tribe. Has anyone followed the news over the last 6 months about Allergan and the St. Regis Mohawk tribe? Couple people have, a lot of people haven't. What I'm going to do is show you a little 2-minute video clip from September 2017 where this made the news. See if I can get this all to work. We've got multiple approaches here. Can't see my mouse to launch the browser. Oh, thank you. Oh, see, and I know what I'll do. Try this. There we go. Yeah, it's a little awkward. I need eyes in the back of my head. Okay, let me see if I can just paste that in there. See if we can get this to go. Here we go.
Today, right now, you have more power at your
Sorry
fingertips
for the ad.
than entire generations that came before you. It's not really about what technology can do. It's about what you can do with it. We are living in the future we always dreamed of. We have mixed reality that changes
when
how
I
we see
tested
the
it
world,
3
and
times,
AI
I didn't get an ad,
empowering us
but
to
perhaps the
change
4th time
world
is when
we
you
see.
now have to have an ad.
So what will you do with it?
And now let's cross our fingers and hope it's the right video clip.
Pretty interesting story to bring you
Here we
here.
go.
Check out shares of Allergan. They've been rising higher this afternoon on an announcement about patents around one of their big eye drugs, Restasis. Now, this is a bit of a complicated story, but it's absolutely amazing when you really dig into it. They have announced that they've transferred the rights, the patents upholding this eye drug, Restasis, to the St. Regis Mohawk tribe. That is because they are facing a number of patent challenges around that drug, one through a system known as Inter Partes Review, or IPR. You may remember that from all the Kyle Bass challenges a couple years ago. Apparently, this Native American tribe has sovereign immunity around IPR challenges, and they're going to seek to dismiss this patent challenge around Restasis. Allergan is going to be paying them about $13 million upfront in exchange for that, maybe $15 million more a year in royalties around Restasis to get this potential challenge dismissed here, guys. I just spoke with Allergan CEO Brent Saunders. He says he thinks this is the first time the system has ever been used in this way. They're basing it on some uses before in universities having that sovereignty here. They say, importantly, this does not get all of their legal challenges off the table. They are still dealing with some challenges through a more traditional system in the federal court. They have pursued this here with this tribe in order just to avoid what they call double jeopardy, guys. But Allergan up about 2% on this news.
So let's look at a couple of the things that we were just told. Try something else since Windows doesn't seem to be launching. Okay, I'm not getting my presentation back up. Is the IT guy long gone? Oh, here. Oh, it's here. So let me try. This little projector there. Now the bad news is that I'm going to toggle back a couple times. Okay, good. Thank you, son. So that little clip, let me hit the couple of the highlights to set the framework of this case study. What I see here isn't always what you guys see. Okay, it's changing the slide here, son, but not back here. Any techies in the house? There we go. Okay, there was just a lag. Okay, here we go. So Allergan, there are 6 patents that cover Restasis. What Allergan did last August, September timeframe is sell those patents for nearly $14 million to this Indian tribe. Allergan said, here, take these patents. We're going to pay you to take these patents. The Indian tribe now owns the 6 patents. That's perfectly legal, right? Patents are a piece of property. Like you can sell your house, you can sell your car, you can sell your patents. Perfectly legal. A little odd to actually pay someone to take them. Usually, you know, someone buys them. But okay, nothing. You can contract to do whatever you want with your personal property. The tribe owns the patents, and in return, the tribe will license the rights back to Allergan in exchange for a royalty on all sales of Restasis worldwide. This is a first in the pharma industry. Now, it's not a first worldwide. The couple of tech companies have been doing this same little ploy here, but it's new in the pharma world, and Allergan has been taking quite a lot of heat over this. So I'm going to leave this story hanging. We're going to return to it at the end of my talk and wrap up on, you know, why did they do this? Well, I'll give you a little teaser now. Starts with this part. Does anyone recognize We the People, Constitution of the United States? There's a certain amendment to that Constitution, the 11th Amendment, that was ratified in 1795. This is the amendment that gives states and tribal nations, they're considered, you know, domestic dependent nations, gives those entities a shield against being sued in federal court. So the tribal nations like the St. Regis Mohawk tribe are domestic dependent nations and are immune from suit in federal and state courts. Patent laws are federal laws, right? The whole patent system is grounded in the Constitution. The body of laws are federal laws. Patent challenges for many patent things are heard in the federal circuit. They're federal laws. The Indian tribe is shielded from that. So this is a way that Allergan can try and shield their patents from certain challenges, namely the inter partes review challenges that we'll talk about at the end of the talk. I'm going to skip over this slide for now. The whole game here that's going on is Allergan trying to protect its Restasis product from generic challengers. 3 companies, Teva, Mylan, and Acorn, all have filed applications with the US FDA seeking to also market a Restasis product under their own label. And the only way Allergan is going to be able to stop this is if they have intellectual property that these 3 parties would infringe. So it's this whole branded generic challenge in the pharma industry that's driving the transaction of the intellectual property to the St. Regis Mohawk tribe, and really brings us right back here tonight on what is the value of intellectual property in the pharmaceutical industry. And these claims that are covering Restasis, they're very interesting to look at because they're claims on a known compound in a known list of ingredients, yet protecting a very commercially important product. So with that background, here's tonight's agenda. We're going to focus first on finding patent information using tools online. This might be a bit of a struggle giving the back and forth, because I was going to go on the web and do some things. We'll see how much progress I can make with that toggling back and forth between the talk. Finding and understanding the patent information. And as we do that, I want to put in context for you, how to find the information, understanding patent claims, understanding the patent documents that are identified in a search, whether they're patent applications, patent publications, granted patents, and also look carefully at the claims of the patent and understand how important the wording of the claims are. Then we're going to move into the patent process itself, filing applications and the process that occurs at the patent office, and then wrap up there on the last bullet point of protecting repurposed drugs, turning back to the Restasis story. So with that, let's start here at the beginning. And as I hadn't, when I started preparing this talk last week, I hadn't really thought about including this section of it of finding and understanding patent information, but I realized that there are so many useful tools on the web that for those of you that are trying to understand where to find patents on things, it would be helpful to have me walk through the process that I went through to try and identify the patents covering Restasis. I didn't prosecute those patents. I don't know them. I had to find all of this information on the web for the talk tonight. And there are some really useful tools to help put your fingers right on what you want to know. So the first one is I wanted to direct you to the Orange Book. It's actually called the Approved Drug Products with Therapeutic Equivalence Evaluations. It's a compilation maintained by the Food and Drug Administration, FDA, and it is now online. It used to be, before all the online days, a hardcover book that had an orange cover, hence it's named the Orange Book. It is now online, and I was actually going to take you there. Let's see if I can get this sequence of events down a little bit easier. Here we go. It here. Do you think I can see the screen from over here? Yeah, maybe I can. Because I can't see the search screen on this computer monitor, so I have to turn around and look. You see? Okay, I'll just turn around and look. I just want to go to Google, and then we can find it just by electronic Orange Book. There it is. Whoops. And she hit the wrong X because I'm at such an odd angle. Okay, this is the Orange Book. And there are lots of search fields here. We know the name of the product that we want to know. Restasis. R-E-S. R-E-S. When you type in the product, and you saw there were other things you can search by, the active agent, patent numbers, all kinds of things. Here are the two products that are approved by FDA. The Restasis cyclosporin once a day, and then there's a multi-dose. If you click here on this hyperlink, this is the NDA application number. You'll see there's another hyperlink to the patent information for the product. So this is where I began to identify, okay, how many patents cover Restasis? What are they? It's required under law that when FDA approves a product, if there are patents covering that product, the new drug applicant filer must provide that listing to the Food and Drug Administration, hence all the data for the Orange Book. So these 6 patents cover Restasis. With these patent numbers in hand, I mean, this also gives you the patent expiration date. It tells you whether it covers the drug product, whether it's a method of use. If it's a method of use type claim, then it has a use code. What I want to do tonight is look at this patent, the 8629111 patent. So from this listing, I was then able to say, okay, I know which patents cover restasis. Those are the ones that we can look at for the claims. See if I can do this again. Oh, I have to go. Did you bring that up over there, son? Oh, there it is. Want that one right there. Yeah, that's right, I have to hit it. Okay, I don't see it over here at all. Okay, I'm going to try not to toggle back and forth. Unless anyone has a better, anyone? No? Okay. Oh, it's probably just a lag, huh? Oh. Have it here, son. So this is the patent, the first one of the 6 that was listed. This is the face page of the patent. A lot of interesting information here that I'm going to walk you through. First, it says U.S. patent on the top. That's obvious. I draw that to your attention now because in a little couple slides from now, we're going to look at a U.S. patent publication, which has different legal implications. So when you first are looking at a document, you should make a distinction. Is it an issued patent, in which case it says United States patent, or is it a published patent application, in which case it'll say that it's a published application. We'll look at one of those in a moment. The next thing to look at is the filing information. It tells you the date that this application was actually filed with the USPTO. There's also a body of information here that gives you related patent information. It's this information that you use to determine how long is this patent in force. Current law in the United States is a patent has a 20-year lifetime, 20 years from the earliest priority date or the earliest filing date, not counting the provisional priority date. So when you look at this here, it lists the provisional application, and we'll talk more about provisional applications in a little while. It lists the provisional application. That never counts to the 20-year filing date. So the rule of 20 years from the earliest filing date is going to be one of these other dates listed here. And as you pick through them, there's a priority date here of August 27th, 2004. That is the earliest date listed on the face of the patent. So your patent term calculation looks something like this. See if I can. August 27th, taking this date here, plus the 20 years. Now there's one other little wrinkle in U.S. law that we call patent term adjustment. Sometimes you can have extra days added on to the 20-year term for delays by the patent office, you know, our government at its finest, taking their sweet time. Well, if they take their sweet time and you as the applicant have been diligent, the government will give you extra days on your 20-year term. And if you get extra days, those will be indicated up here. This was 0 days, meaning the government didn't take their sweet time. They got to work and got the patent issued. So this calculation is just 20 years from the earliest filing date of August 27, 2004 and expires on August 27, 2024, which is the exact date that was listed in the Orange Book if you were looking carefully and paying attention. Okay. The other tip on patents, though, when you have an issued patent and you're looking at it, and if you're worried about that patent in terms of will your product infringe its claims, always check and see if the maintenance fees have been paid on the issued patent. Now, I was going to demonstrate how to do this to you, but I'm not because of obvious technical reasons. the USPTO website, if you just go to the website and type into the search box maintenance fees, patents, it will take you to a maintenance fee storefront that looks like this. And you type in the patent number and the application number. Oh, I got to show you where the application number is. See, the face page of the patent is just filled with information. You type in those two numbers into the search boxes and hit continue, and it will bring up a page that tells you if the maintenance fees have been paid, if they're due. If they haven't been paid, it will say patent is expired. Once the patent is expired, it's possible to revive a patent by paying a fee and claiming, oh gosh, it slipped through the cracks, you know, inadvertently the fees weren't paid, and sometimes they're revived, but that period for revival is, I mean, if you do it at a year and later, you're kind of pushing the boundary of did it really slip through the cracks or did you change your mind? You can't revive it if you just changed your mind and decided later you want to pay it. But if it was a true mistake, you can pay a revival fee. So if the maintenance fee is missed by, say, a year or less, you know, you might be okay, they might revive it. If it's a year or more, probably they're not going to revive that patent and it's now expired, has no legally enforceable rights. So I'll always check for maintenance fees because they get expensive as the patent matures and gets closer to its 20-year term, and a lot of companies don't keep the patents going because they take money. You have to pay. Okay. Every patent ends with a set of claims. It's the last thing that's listed in the patent. And it's the claims that are the most important part of the patent legally. Those claims define the legal boundaries. They're no different than the legal boundaries around your house, you know, around the four corners of your car. The words of the claims define what the patent owner has the right to stop others from doing. Let's look more carefully at this claim that covers restasis from this patent. So it reads, a topical ophthalmic emulsion. Emulsion is important, right? It's not a solution. If your product was a solution, this claim only protects an emulsion. Okay, cyclosporin is so insoluble that probably it's hard to have a solution of it, but every word matters. So you have an emulsion for treating an eye of a human. What if the claim said an eye of a dog and you wanted to give it to a human? This claim only covers treating an eye of a human. And that's how, when you read through a claim, every word matters and defines what that owner has the right to stop others from doing. So this emulsion comprises cyclosporin A. You could use cyclosporin B, C, or D and avoid this claim in an amount of about 0.05%. Pretty precise, isn't it? What if you used 0.06% or 0.04% in your competitor, in your competing formulation? What if Merck, who is one of the companies, or Teva that wants a generic, decided to use slightly different weight percent? Well, they'd be outside the scope of the claim, but then they can't use the same safety and efficacy data that Allergan used, and then if you use a slightly different weight percent, you have to do all your own safety and efficacy data with the FDA, and you kind of avoid the advantage of being a generic and trying to, you know, just use someone else's safety and efficacy data. So this claim also, yeah. That's good. It is a little looser than 0.05, the about part. Thank you for catching that. So claims are interpreted in light of what occurred in the back and forth process with the patent examiner, and we're going to look at that process. So if there was a prior art reference cited by the examiner during prosecution of these claims that had 0.1 weight percent and the applicant amended to about 0.05, then there's some wiggle room around how legally the 0.05 is read because of the word about, but we know it can't be up to 0.1 because that was already in the prior art. So what the about means depends on a couple things. What was cited during the prosecution of the claim did the applicant define the word about in the application? Sometimes there's a definition of about means 10%. Legally, for me, when I'm advising my clients and I'm not sure what about means, I tell them that usually 25 to 30% on either side is about the most that I see in the case law of an about term encompassing. And that would be sort of my initial reaction, but then might change depending on a couple other things that we've talked about, the prior art that was cited and whether or not it's defined. So yes, about is actually, you know, useful to have in the claim because it does give some wiggle room around the exact number. The claim goes on to recite the couple other components that are in the formulation: castor oil in an amount of about 1.25% by weight. And then there's this strange clause where cyclosporin A is the only peptide present in the topical emulsion. When I read that claim, these where-in clauses, I know immediately that that's because of something that the examiner cited in the prior art, that was needed to be added to avoid something that was in the prior art, because it's a little bit strange to actually lead with that claim. So that is the main independent claim in this issued patent. There are a couple of other independent claims that we'll look at later. The next claim, Claim 2, here, you'll see that it depends from Claim 1. Any claim that recites back to another claim is what we call a dependent claim. The dependent claims further narrow the independent claim from which they depend. So Claim 2 here, if you read it in its entirety, you would read all of Claim 1, and then you'd say that the topical formulation further comprises a tonicity agent or demulcent component. Demulcent, that was a word I didn't know, I confess, and I had to look it up, but it's the glycerin that's present in the formulation. So I think one of the things that I hope you take away here is this appreciation of how to read claims, and that when you look at a dependent claim, it's further narrowing what is described in the broader claim. So this Claim 1, the independent claim, doesn't require a tonicity agent or a demulcent component. Yes, John. Mm-hmm. Mm-hmm. That's right. Mm-hmm. Once a competitor emulsion has each of the components listed here, they infringe the claim. Even if they add one other thing, three other things, they have the basic minimum of what's required here, and they would infringe the claim. Perhaps what you're asking is, suppose a competitor to this Restasis product added a component that reacted maybe with the copolymer. Is that the only thing that maybe might react here? Yeah, there may be an argument for non-infringement there. And I think it depends on could the claim capture the infringer at the moment of manufacture before the reaction is complete? What's the timing for that reaction? I would think through that piece as well to make sure that there isn't an argument that the composition of the claim existed even for a second at the moment of manufacture. Yes. Yes, it would still be an infringement. Did everyone hear the question? The question was, suppose I added another component to the components that are listed in Claim 1, and that additional component gave stability for 5 years instead of 1 year. So that composition with an additional component would still infringe this claim, because this claim requires only these certain ones be listed. If you add anything else to it, you still infringe. But what you're saying is that addition of that other component gives an improvement in shelf life. You could patent that as an improvement, but you're not free to operate with that, because you still would infringe this claim even though yours might be patentable over this claim. Does that make sense to everyone? This is a great point that he's bringing up, and understanding this tension between a broad claim that is owned by someone, an improvement that you might make, and you would own a patent to that improvement, but you're not free to operate or commercialize that improvement without a license to the broader claim.
Well, if I change out, has no change, am I still violating the patent?
No. Right. That's right. FDA wouldn't like the motor oil, probably, and a competitor wouldn't do that unless they wanted to do full clinical trials. I mean, the whole point of generic drugs is copycat exactly to leverage off the safety and efficacy data that the branded drug has already filed with the FDA. Good questions. It helps me clarify and hammer this home. Yeah, Nancy. Yes. Mm-hmm. Yeah, thank you for that. And if you sit tight, by about 6:45 or 6:50, we're going to be there, and you're going to see how this plays out. Yeah, yeah. Okay, so claims. The next thing that I wanted to impart for you is this concept of patent application publications. The face of the patent, again, this packed full of information patent face, gives you when this issued patent was earlier published and gives you this long number. So I pulled a copy of that. Thankfully, I didn't plan on going online to get you a copy of that, because we wouldn't have looked at it then. Here's this publication. It says across the top, patent application publication. A published patent application has no legal rights. I mean, Allergan filed this, it published, but there are no legal rights in a publication that can be enforced. Only an issued patent has legally enforceable rights. So if you are looking at patent documents and you see that it's a patent application publication, really the question that you want to ask yourself is, did that application that's published ever mature into a patent? And you can find this out online. And I do really want to show you how to do this online. Help me out here. Should I do it? Should I not do it? Do it? Okay. Even with all the awkwardness? Okay. So the USPTO website is, this is the go-to tool that I use. I always have to remember my sequence of events here. Okay. I'm going to go to USPTO, and I'm told that, I don't know what uspto.com is. I'm not sure I want to try it in a group setting. So uspto.gov. Now I know you're all going to go there and look. Okay, let's see. Okay, here it is. So here's the USPTO website. I always go straight to the patent tab here. And there's this little portal here that we call PAIR, Patent Application Information Retrieval. This is a gold mine. If you click on PAIR, then the public has access to all the information that goes on back and forth between a patent applicant and the patent office once the application is published. So as soon as you know that publication number, you can go and see everything that's happening with the patent office. Okay. They used to have this simple CAPTCHA thing, and now they want you to like really test your skill set like a toddler. Oh, and I failed. Street signs. Did I get all the street signs? Those are doors, right? Okay. Oh dear, how embarrassing is this? Select all that have street signs. Do you think I have to do that one too? No? Okay, so there's dissension among Stanford people. It's not just me. Okay, who says I do the post and who says I don't? All hands? Okay, Bob says that I do the post. Oh! Okay. Oh! Okay, we're doing the post this time. Now you'll see why they pay patent attorneys so much. It's because we sit here and do this all day. Okay, if this doesn't... How many times did that take? Okay. Oh. Okay. Let's see, I jotted it down in case I didn't have it handy. I knew this could be tricky. Okay, so you need to put in either the application number or the publication number. I usually do the application number because it's shorter, and remember, that's right on the face page of the patent, so I'm going to type in 13967-163. 163, and you hit search. And here it is. So this is the complete file that the patent office maintains that shows everything that happened between the patent applicant and the patent office for this patent that covers restasis. So the most interesting part, I mean, it gives you assignment, you know, the publication, the image file wrapper are all the documents, and I'll just flip this around so it's easy. You can see that the application was filed in 2013, and then every one of these, you can download them, the PDF files over here. The application is originally filed, and then all of the back and forth with the patent office. The relevant things to look at are things like, oh, they prioritize this. You can pay an extra fee at the patent office of about $4,000. It's not tiny. And the patent office will take your application ahead of everyone else's. That's what the track 1 request is. And then here's the first office action from the examiner, the non-final. And then you can see they interviewed the case, and you can click on all of these and open them up and see what happened. And when you're trying to understand patent claims and what the about term might mean, it's this file that I go to as an attorney to understand everything that happened leading up to grant of those claims. So this is a way you can also, when you have a published patent application, understand, was it ever granted as a patent? You put in that serial number that's assigned or the publication number and look and see, did it issue as a patent? Let's see, the application data here. So it gives you the publication number, and then it tells you patent number here. And then you can also click and see, did they file any continuation applications based on this when it granted? And no, they didn't. This one came to grant, and they filed no further continuations, meaning that it's closed and they can't claim anything more in the application. So this is a great tool to know how to use to understand whether applications matured to a patent, what did they argue, what prior art was cited against the claims, just a wealth of competitor intelligence here. Okay. looking. Nobody's. Oh yeah, there's a lag. I just have to be patient. Got it? Okay. For those of you that are interested in really understanding worldwide patent protection, I wanted to draw your attention to this website that I'm not going to demonstrate. Go to Google and just type in eSpaceNet, and it'll go to this website. And if you put into the smart search box the U.S. patent or the U.S. patent application and hit search, a page will be generated that identifies the document that you put in, and over on the left-hand side of the page, there's a little box that you can click that says Impedoc Patent Family, and it will give you all the patent applications worldwide related to the one that you put in. So for the Restasis patent, I can put in that patent number, pull up the patent family, and I can see, did they file in Europe? What is the number? Did they file in Japan? Did they file in China? So it's a nice, easy way to get the whole patent family for that specific patent. Google does a similar thing. You can put the patent number into Google Patents. What I find with Google Patents, though, is it'll pull in so much information that it's hard to sort of sort through. This gives it to you in a very nice table that identifies exactly what's related to that patent that you put in. So for worldwide searching, this is my go-to free site. Okay, so from this part of the talk, here are my takeaway points for you. I think I just have to be patient and let it do its thing. Here we go. Granted patents are legally enforceable rights, provided the maintenance fees are paid to keep it in force, versus a published patent application that also ends with the listing of claims, but the published application is not a legally enforceable right. The USPTO has a good search site that I didn't demonstrate. I skipped over that here because of the pain of going back and forth. And the PAIR database is really a good place to go to get information on particular patents and particular patent applications. The Orange Book is also a really good starting point when you know a drug product and you want to understand whether or not there are patents that cover that drug product. The Orange Book is a good tool to use. The other takeaway is the 20-year term and how to calculate that for patents. This is 20 years. It's worldwide. All patents have a 20-year term, from their earliest filing date around the world. And then the eSpace tool to find patent families. Yes, question. Thank you. I like questions. So the incentive is that hopefully that published application will mature into an issued patent. When an application is filed with the United States, it will be published 18 months after filing, unless, with the U.S. there's always like little caveats and exceptions. It will be published unless the applicant indicates that they do not intend to foreign file the application and requests non-publication. But in the pharma industry, all applicants are foreign filing for worldwide protection, and so U.S. applications will publish. does that answer your question? Does it put in context? We're going to look at the patent process, and you'll see from filing an application to publication and then how it becomes a mature patent. That might help you put it more into context as well. Bob?
One thing you might point out, difference between each Google patents. In large part, the Google patents have been put through optical character recognition, where space your images. You have a 500-page patent by search, and not have to read through the whole image file. Sometimes, not all the patents that they have in Google are processed that way. If you can't download also published as, sometimes one of the versions has been published.
Searchable, yeah. I find I use a combination of the tools.
Yeah.
You know, I'll often find the patent family and then go to Google Patent to pull it up where it's in, you know, a searchable HTML version, and then I can do a word search for things. Yeah. So in the last hour, we've covered these topics. It's a good time to pause if there are any questions or anything that you want me to flesh out a little bit more before we move on. Kevin? Mm-hmm. Of course. When a patent is being examined by a patent examiner, that examiner, he or she, looks at the patent claims and has to decide, are these claims in front of me novel, not obvious? We'll talk a little bit about that in the next section. In order to make that assessment, the patent examiner does a search and looks at, okay, what's already known out in the public domain, known prior to the filing date of that patent. Anything published prior to the filing date of the patent is what this term we call prior art. It's art, okay, you know, scientific journal articles, you know, anything that's published or even spoken is art prior to a filing date, hence prior art. So patent applications, when they publish, as of their publication date, become a publication and can serve as prior art to anything that is filed after that. Yeah, so, you know, Allergan's first filings on cyclosporin that published are prior art against their later applications that are filed at a later point in time. We'll look a little bit at this novelty, non-obviousness, and prior art assessment as we walk through the patent phase of in the next section here. Okay. Let's see, you had a question as well. Okay. Yes. Anything that is published becomes prior art, yes, and will forever be prior art, yep. Question? Yeah, so the Patent Office has a whole search division. The patent examiners are trained to search, but they also have searchers, and they have access to all kinds of databases that probably I don't even have access to. They find conference proceedings. I have examiners use the Wayback Machine and find bizarre websites. Oh, you can answer this. Google. So this is a patent examiner who I've interviewed with at the Patent Office several times, and he can, how were you trained to search? Google Scholar. Thank you. Good. Okay. Yes. Yeah. Will you prompt me with that question again when we're looking at the patent cycle? I'm trying to think if it'll make more sense for people then when we're looking at, okay, we have an issued patent and then we can do continuations and divisional. So let me bring that up as we're talking about the patent process. And if I forget, ask me again. Right. Okay, so we'll move into the second half here to talk about the patent process. And going back to the face page of our Restasis patent, you'll remember that we looked at this filing date, the provisional application in September of 2003. That time I was making the point about that filing date does not count to your 20-year patent term, right? The 20-year patent term is actually begins calculating from the later date of August 27th, 2004. This is one of the upsides of the provisional application process in the United States. Provisional application is filed, assigned a number by the patent office, but it doesn't begin the 20-year patent term. That gives you a year as the applicant to do further research, see if you can find a partner or a licensee or someone to help carry the costs of the project and the patent process forward, but gives you sort of a mark in the sand of this is my invention, I've filed it, and you're then free to talk about the scope of that invention because it is filed with the patent office and nobody can steal it from you if you begin talking about it. So in today's world, especially in the pharma industry, a provisional application is what is first filed. You don't have to file a provisional as the starting point. You could go straight to filing the non-provisional, which is what's filed a year later. But in the pharma world, people take advantage of this 1 year, and because it takes so long to get through clinical trials, pharma companies are not in a hurry to get their patent, typically, and it's better just to let it take its time and get the clinical trials finished before you start moving through the patent process. So provisional applications, to recap some of the things I've just told you here, they're not ever published. A provisional patent application will not mature into a granted patent unless it's refiled 1 year later as a non-provisional, and then it begins moving through the patent prosecution process. While provisional applications themselves are never published, they do become publicly available when a non-provisional application claims priority to that provisional, and then the provisional becomes available on the PAIR website that I showed you. So we looked at the patent application publication for Restasis. That publication matured into the issued patent that we've been looking at all evening long. When that application published, it referenced this provisional as its priority document, and then that provisional is publicly available on PAIR. I'll try and project, and I suspect I'll be okay. Is it? Can you hear me in the back of the room? Yeah. I'll do my best. Yeah, I need another hand, especially if I have to go back online. Fortunately, I don't. And now I've completely forgotten the question. Who's going to help me out here? Yeah. Yes. the provisional is always interesting to look at to understand, did the applicant at the time of filing the provisional have the full scope of the invention fully thought through, in patent words, fully enabled? I mean, did it, you know, and where that really becomes critical is if the patent applicant disclosed the invention after the provisional was filed, and perhaps disclosed more than what was in the provisional, then that public disclosure, the delta between the public disclosure and the provisional can be used to invalidate the later claims. So when you file a provisional, yes, you do want it to be as full, complete, and thought through as possible. You need to fully describe the invention, because if you add information during that 1-year period that isn't fully supported in the provisional, there can be questions of whether or not you're entitled to that priority date. There's an echo when I use this. Do other people hear the echo? Okay. All right. I think, so let's continue with the patent process. I skipped over this slide quickly, but from this slide I'm grabbing the dates that you'll see on the next slide. We have a provisional application filed, and then about one year later, Allergan moved forward with filing the non-provisional. So here's our provisional that was filed with the Patent Office on September 15th, 2003. By law, the provisional must be refiled as a non-provisional within 1 year. Otherwise, you can't claim the benefit of that earlier September 2003 priority date. So here Allergan actually filed it on August 27th, 2004. More normally, you'll see it filed on the same date. Probably their attorney was going on holiday or something and needed to get it done before they left. That would be my guess on why this date is not September 14th or 15th, 2003. So this non-provisional is the document that eventually will publish and goes through the patent prosecution process at the USPTO. Let's talk a little bit about that process. So here we have our two documents. I'm putting a little box here as a placeholder. We're going to talk a couple slides coming up on international applications. That non-provisional that's filed at the Patent Office publishes 18 months from the earliest priority date, which is this provisional date. So 1 year plus 6 is 18 months. It will publish here. The application sits at the Patent Office until an examiner can get to it. It can take a while, but actually it's gotten better over the last couple years. It used to take 2 to 3 years maybe to have an examiner take it up, look at the claims, and render their opinion on whether or not those claims are patentable. It's a bit faster now, and typically I'm seeing a first office action coming often within the 14 months from this filing date. So in this first office action, the patent examiner who's in charge of this application will look at the claims, quickly review the specification, conduct a search, and determine if those claims meet the patentability standards. Are the claims novel? Are they not obvious? Are they directed to patent-eligible subject matter? And are they fully enabled by the description in the application, and is there a sufficient written description? So the patent examiner will always reject your claims. That's how it works. And if the patent examiner doesn't reject your claims weren't broad enough. It's just that simple. So expect that first action is going to be a full rejection of the claims. That's how you want the process to play out, because you want to do this back and forth negotiation to try and figure out where are those right legal boundaries? What are the right words in the claims? You know, do you really have to add 0.125% glycerin in the claim or not? I mean, it's a negotiation back and forth. So you get this office action, it's in writing, and the applicant must respond in writing to the office action within 6 months for sure, 3 months ideally. The response to the office action can include amendments to the claims and all the reasons why the examiner is wrong about his or her analysis of the patentability of the claims. Then the examiner will look at the written response and will do one of two things: issue a final office action or a notice of allowance. Now, a notice of allowance is actually pretty rare at this stage of the game, but if you get a notice of allowance here, you pay another fee to the patent office and your patent grants. Excellent. But most often, what happens here is the examiner is still not convinced that the claims are patentable and will issue what they call a final office action. Let's look at what your options are when you get this final office action. Typically, the applicant will file a written response to the final office action. However, it's at the examiner's discretion whether he or she will consider that response at this time. Normally, they won't, especially if you're amending the claim in any way whatsoever. But that's okay, because we have another tool in our toolbox. Just costs a little money. It's called a request for continued exam. You pay another fee to the patent office. The examiner will consider your written response that was put in over here and issue what now would be your third office action. So I purposely illustrate this as a circle because it can go on as long as the applicant is willing to stay in this circle. And sometimes it's a business strategy to do that. And sometimes that's where you hope the examiners are so busy that they take their time, looking at your responses so that you stay in this circle. Competitors are watching your patent filings, and sometimes you want to keep things pending. If the examiner is taking things up too quickly and you can't stay in this circle for long periods of time, you can bump it over to appeal and maybe try and park it there for a while. So you can, use the knowledge of how the system works to stay in if you don't want your claims granted. Sometimes you don't. Or use this to try and move it through and get granted claims. But this is the basic process. Now, I'm looking at my friend over here who raised a question. Why would you not want it to be granted? In fact, I had one of those today where the client they're waiting for some additional data out of phase 2 to decide if they're going to go forward or not. So we want to try and delay expenses in the patent process because the phase 2 data may not be what they think, in which case the whole program is going to go down. So we want to minimize our patent expenses, but I need to keep things pending in case the data looks good and we want to move forward. So sometimes you're just playing this game for financial reasons, data reasons. Yeah.
Sun, the stars, and the moon. So the patent office. You don't want your competitors to know you're only getting for claims you're going to get while your patents are going to be everything you want.
Yeah. And I guess I can use your answer and example there to answer your question about continuations. So one of the options is if your claim is the sun and the stars and the moon, and the examiner will only allow your claim to the moon, you can go ahead and take the allowance on that claim to the moon, but file a continuing application to the sun and the stars. A continuing application simply refiles the same application, but with different claims. And that same application will make a priority claim back to the earlier application and to the provisional. In fact, if you think of the face page of the Restasis patent that we've looked at how many times tonight, and it has all that related U.S. information, there were 3 U.S. cases listed on the face of that in addition to that provisional. Those were continuation applications of each other. So they refile the application in order to claim different subject matter. Sometimes, you know, you might seek a claim that has 0.05 weight percent cyclosporin and another claim with maybe the word about doesn't occur in the other claim. You know, you can modify the claims by way of continuation applications. Now, we also have in the U.S. divisional applications. Divisionals it's the same concept of refiling an existing application, but the claims in a divisional must be derived from a restriction requirement by the examiner during examination. Often the first step an examiner will take when he or she looks at the claims that are filed is to decide, well, half of these claims are to the composition, the other half are to a method of treatment. Those are two different inventions, two different searches need to be done. Applicant, you're entitled to one invention per patent. Pick one. So you pick either the composition and then you can pursue the method claims by way of divisional or vice versa. Okay. We also have in the United States continuation in part. I rarely use continuation in part. Continuation in part is an application where additional information is added to it, maybe a couple paragraphs about salt forms or, you know, something. A continuation in part application only makes sense if the earlier filed application has not yet published. Otherwise, that earlier filed application is prior art against the continuation in part. So continuation in parts need to be looked at carefully and to make sure the parent that it's claiming prior to hasn't published yet. Yes, one more. And speak up so that they can hear you way over there. So the question is about the continuation application. When you file a continuation application, you cannot add new matter to the application. All you can do is present new and different claims, but those claims must be grounded and based in the application as it was originally filed. Okay? All right. This slide here was a placeholder to reiterate for you that all of this information, office actions, responses, requests for continuing exam, allowances, all of that is on the public payer site that we looked at earlier today. So once the application is published, it's all public information. I'm often asked about the costs of patenting. So I have a slide here to give you a flavor for that. Provisional applications range in cost. I mean, $8,000 is actually difficult at my billing rate. $15,000 is a reasonable budget for a fully written provisional that is thought through, has a set of claims. They can go higher than that, particularly in the biotech area if there are a lot of sequences, or in the chemical area where there are a lot of compounds. The non-provisional application, the costs involved in preparing that document are directly proportional to how much or how little you did in the provisional application. Once the non-provisional application is filed, it is locked down, right? You can't add more information to it. So that document, the non-provisional, needs to be very carefully thought through. In the future, after it's filed, all you can do is change the claims, but only within claims that are within the four corners of the document as filed. So typically, if the non-provisional, if I've written a very complete provisional and there's no new data, wouldn't cost anything to get that non-provisional ready to file. I might think about the claims a little bit and make sure they're ready to go. But then the Patent Office charges a $1,600 fee for a large entity in order to take that application through the filing process. The Patent Office offers a discount for small entities of 50%, and then there's also these micro entities that I've never had the benefit of using, but if you don't file many applications and your annual income is under a certain amount, you can get a 75% discount off the USPTO fees. The next round of fees occur when a response to an office action is needed and the attorney time is taken to look at that document and assess the prior art, figure out how to amend the claims and respond to the examiner. And then a fee, of course, when you pay the issue fee. I think actually the fee may be $1,200 now for a large entity. And then these RCE fees used to be a fixed fee. They now escalate, I believe, a little bit each time. The first RCE costs a certain amount. The second RCE is a little bit more. They're trying to discourage applicants from staying in this circle by making it more expensive. But you can see this is just for one application. And I think it'll give you an appreciation for companies that have, well, even the Restasis product has 6 patents. It's an expensive process for just one, but when you're multiplying that by 6 and then you have foreign counterparts, it's a big budget that we're talking about. International applications, I had this little placeholder on one of the slides. International applications are also due at the 1-year priority date. To take advantage of this provisional priority date, the international applications need to be filed at the same time as the U.S. non-provisional. International applications are most often done by way of what we call a PCT application, Patent Cooperation Treaty. That application that is filed as a PCT application goes through a defined process, much like the U.S. applications. A PCT examiner will look at the application, render a written opinion on patentability of the claims. That application publishes as a PCT patent publication. And then by what we call 30 months from the provisional date, so the sum of 12, 4, 2, and 12 is 30 months. By 30 months, this PCT application must be filed in any member country of the PCT where the applicant desires patent protection. There are currently, I think, just over 140 countries that are members of the PCT. If the application is filed in Japan, it must be translated in Japanese. If it's filed in Korea, it's translated into Korea. Every country requires it be in their language. So the costs of going from an English PCT application to just say these, what do I have here, 3 by 3 and 9 countries would probably be about $80,000 just for filing, to pay the filing fee in each country, the translation of the application into each country language, and then whatever fees are attached by the attorney handling it in each country. I'm a U.S. attorney. I can't file in Europe. I need a European attorney that I hire to do that, and they always attach a fee as well. So after these are filed in each country, they go through a process much like the United States, which with costs at each stage. You can get an idea of the budget from there. Yes.
I have a question.
Yes.
So, this morning, Sarah, can you talk about which country?
Did everyone hear the question? I'll take silence to be a yes. Yes, thank you. I see the heads nodding. It's a business decision about where to file, of course. And for large pharma companies, they actually have a list of tier 1, tier 2, tier 3 countries. And depending on the market and expectations for the product, they'll decide whether they file in 5 countries, 15, or 35 countries. For smaller companies, it's this balance of how much budget do we have, who are the potential partners, and what's the market in the countries. So you triangulate those 3 things. If you really think that your key partner is going to be in Japan, you want to file in Japan, assuming there's some market in Japan. I'm doing some work right now with a company that has a topical formulation for treating basal cell carcinoma. And so the marketing people have looked really carefully at which countries does BCC occur. And there are a number of countries where it's just not prevalent in the population because of their skin types. So we've carved those off as we're not filing there. So you can see it's really, it's more a business decision, but then the finances come into play. That's how the decision is made. All right, I think we've made all these points. Let's move on. We've got 30 minutes to move through this last little piece here. We looked at this patent early on. This is the original Sandoz patent on the cyclosporin compound itself. I'm going to set up this timeline to help you put in context a couple things about patenting these repurposed drugs. So I know from the literature and from reading that cyclosporin patent that the compound was discovered and characterized between 71 and 76. Sandoz had their patent issue in 1978 and it expired in 1995. Now the next thing that I know is that Allergan filed for FDA approval of the Restasis product in 1999. You know, got me thinking, you know, Allergan must have had some IP before the ones that we looked at, because remember that the provisional priority date on that Allergan was September 2003, but they actually first filed for FDA protection in 99. FDA questioned the efficacy, whether 0.05 or 0.1% was needed, and made them redo the phase 3 clinical trials. So I got to digging around a little bit. Oh, here, I wanted to just remind you of the amazing sales of this product. I got to digging around a little bit. It's amazing what you can find when you do go to Google and start, you know, Googling cyclosporin, Restasis, FDA. You can get to the original FDA filing documents. And in those filing documents by Allergan, they listed 3 patents that they'd licensed, 2 of them from the University of Georgia Research Foundation. This patent has claims to a method for enhancing or restoring lacrimal gland tearing comprising topically administering cyclosporin to the eye in a pharmaceutically acceptable vehicle. Now, this sets the stage for what I want to talk about. I've shown you now the patent that Sandoz had on cyclosporin, right? The compound was covered in the prior art. I also know that this foundation was at the University of Georgia Research Foundation, has an issued patent on topically administering cyclosporin to eye in a pharmaceutically acceptable vehicle. Now, when you think about the Restasis formulation, you got to ask, what's patentable here? Yeah, Dari asks, you know, would the claim like this be allowed today? Probably not, because topical administration of a compound to an eye, I mean, there's nothing that's not obvious about that. You'd have to, in order to make this claim patentable in today's world, I think you'd have to demonstrate that the scientific literature really taught away from administration to the eye, and that no scientist in the world would have believed that it was possible or probable, and that you've shown that it can be done. That would be a tall order. But nonetheless, this is prior art, this claim, against Allergan's Restasis formulation that I've listed here. So you have to ask yourself, how did Allergan obtain 6 patents on their Restasis formulation, knowing that cyclosporin is prior art, and that this concept of administering cyclosporin to the eye is also prior art to their formulation? And it gets worse when you look at it. This patent actually even calls out castor oil in one of its dependent claims. This patent expired in June 2006, and when you look at our timeline, so I know from the FDA filings that Allergan had a license to that Georgia patent, but it would only give 3 years of patent exclusivity after marketing. So Allergan is highly motivated. They've put all this money into clinical trials. They have a product that's approved by FDA. They're going to try anything to get additional patent protection. So even though their formulation, there were some big prior art issues, known drug, known to topically administer it to the eye, indeed, Allergan goes forward trying to patent their formulation, and this is one of the 6 patents that they obtained. Now, we looked at the claims of this patent, I think, are coming up next. There they are. That is why these claims are so incredibly narrow, right? They call out so many of the components, the weight percent, and in arguing for patentability here, the Allergan attorneys put in additional data showing that this ratio of cyclosporin to castor oil, the ratio when they're in these weight percents, give an unexpected result. And that still is a viable way in today's world, is that indeed if things perform in an unexpected way at particular ratios, that is a way to address an obviousness rejection at the patent office. And that's what Allergan relied on. I wanted to put this other claim up. I'll come to you in just one second. This other claim is Claim 18 from the same patent, and you'll see that it's even more narrow in its recitation of the actual weight percents that are in the formulation that are set forth here. So the question that I pose to you here is such a narrow claim valuable? Okay, ponder on that while I turn to you and ask, you have a question. Yeah, so there's some case law in that area that talks about an unexpected result really has to be an unexpected, what are the right words I'm looking for? It's not an unexpected in degree, as in optimizing, but unexpected in kind. So it would need to be a pretty significant, improvement in I think here, Allergan had measured the smear test, the amount of tearing that naturally occurs with and without the formulation applied, where the formulations applied had different ratios of castor oil to cyclosporin. And the amount of tearing that occurs at this particular weight ratio was, well off the plot of something like this. It jumped way up, and they could demonstrate they had an unexpected improvement at that particular ratio. That's how you handle that. Narrow patent claims. This is a very narrow patent claim. And I'm going to try and just move forward here to the points I want to make. Why is a narrow patent claim like this worth all the effort? That's the message that I want to impart to you here in this next series of slides. We'll return back to our opening framework with the transfer to the St. Regis Mohawk tribe. The first important point that I want to leave with you is, in this analysis, is that when an applicant files for FDA approval of a drug or a new formulation, the FDA, once it's approved, will give that NDA applicant a period of regulatory exclusivity. That's either 5 years if it's a new chemical entity. Cyclosporin is not. It was an old known chemical entity. So upon approval of the Restasis new drug application, Allergan would have received a 3-year regulatory exclusivity period. Let's put that in the context of a timeline here. Allergan received FDA approval in 2003. And so for a period of 3 years after that, the FDA will not approve a generic Restasis product. So Merck, Teva, Acorn, any of the generic companies can go ahead and file their abbreviated new drug application with the FDA during this 3-year period, but FDA won't approve it, the generic, until after the 3-year period. But after that 3-year regulatory exclusivity period is up, absent any other kind of protection for the product, meaning if there are no patents, then the generics are free to commercialize. Okay, everyone with me? So, imagine Teva, right? They see this huge product that's garnering $1 billion a year. They want a piece of that, right? So their approach is to copycat Restasis, file their application, abbreviated new drug application with the FDA, using the safety and efficacy data of Allergan in order to seek approval to market their own generic version of Restasis. If there are no patents, if none of those 6 Restasis patents existed, then Teva would be free to market. But it's the patents here that become the next stumbling block when the regulatory exclusivity period ends, and Teva somehow has to deal with those patents. So when Teva files their abbreviated new drug application with the FDA, under the law, Teva is required to make a statement in that application about how they're going to deal with the patents that are in the Orange Book for Restasis, right? This all makes sense now because you've looked at the Orange Book. Teva can Teva can wait until after 2024. We know they're not motivated to do that. So Teva will make a statement to the FDA saying that they believe those patents are invalid. There we go. Under the rules, they have to make this a statement about the patents, about how they're going to deal with it. In fact, there are 4 statements they could make. They could say that there's no Orange Book listed patents. Teva could say that the Orange Book patents have expired. We know neither of those are true for Restasis. There are Orange Book patents. They don't expire until 2024. Teva wants to launch their drug before the patents expire, so the only statement Teva can make is to say that the patents are invalid or they don't infringe them. We know they infringe them because they're copying the formulation to use the safety and efficacy data. So Teva makes this statement called a paragraph 4 certification, and that sets in motion certain laws. The law that it sets in motion entitles Allergan to bring suit against Teva in a court of law. Now, Teva hasn't actually launched a product, so there's no actual infringement. This is an artificial legal construction that gives the patent owner the right to sue the generic company. So, of course, Allergan does that because as soon as Allergan brings suit against the generic filer, the law automatically attaches a 30-month period where FDA cannot approve the generic application. 30 months when you're Restasis, that's 2.5 years at $1 billion a year. I mean, that well pays for your legal fees of bringing suit right here, right? This is just how the law is written. So this is why the patent, even a very narrow claim, is hugely important. Without the Orange Book patent, none of these processes and the 30-month stay would not be triggered. You must have an Orange Book patent to get these laws to come into play. Yeah, why did Teva wait till 2015? And in fact, Teva, Acorn, and Mylan all filed with the FDA in 2015. I don't know why they waited. I'm not aware of any other patents, and the market, as of 2012, was already, well approaching $1 billion by 2012. So I don't know why they waited. All of these laws with the stay are back to the 80s. So, normally in today's world, you see the generic companies filing within 6 months after the branded hitting the market. So I don't know why they waited. don't actually, because I think the point of patentability for the Allergan patents on unexpected result is still recognized post-KSR. So the thing that has changed in today's world is, okay, we have this court case going on. In today's patent world, we also have another vehicle for challenging patents, and this is the inter-parties review proceedings at the patent office. So Teva has the right, and indeed exercised this right, to file a petition with the patent office, asking the patent office to relook at these Restasis patents and determine whether or not they really are non-obvious. The generic companies like Teva are very motivated to take on this inter-parties review process. I'm going to skip over this for now, because the inter-parties review process is very quick relative to a court case. We know that this court case indeed is, I'll tell you the outcome in a few minutes because we had an outcome on this court case in October. This court case was in play. We know that the 30-month stay means that Teva cannot commercialize until 2017 or 2018. If Teva challenges the patents that are at issue in the court case and can get them knocked out within 18 months, they can go to market before 2017 or 2018. So Teva challenges the patents at the USPTO, hoping to invalidate them. So what does Allergan do? That's when this came into play. Allergan said, if I transfer ownership of my Allergan patents to the St. Regis Mohawk tribe, the St. Regis Mohawk tribe is shielded from the proceedings at the patent office, which are federal proceedings. So Allergan transferred the patents to the Mohawk tribe in order to knock out that proceeding here. I don't think we've had a ruling yet. Have you been following this? Okay. Yeah. I don't think we have a ruling yet from the patent office on, there's been a lot of eyebrow raising over the transaction because, it was a pure play to try and avoid this proceeding at the patent office. And, should that be okay when it was really a sham transaction to avoid a legal proceeding? You can argue it both ways, can't you? If it's within the scope of the law, why not? So we're still waiting for a decision on this piece. But right now, the St. Regis Mohawk tribe has been joined as a party to the patent office proceeding, and they're asking that it be dismissed because they're immune under the Sovereign Immunity 11th Amendment. That leaves this court case still in play, but in fact, we had a decision from that just in the last 2 or 3 weeks where the court in the Eastern District of Texas invalidated the Restasis patents as obvious, that the unexpected result really wasn't that unexpected, and that the patents are invalid. Allergan is, of course, appealing this, and so the story will continue. Yep. It's a good question. The generic will be able to sell it, but they sell at risk. Because if during the appeal proceeding, the lower court is overturned, then they would have been infringing, and so they sell at risk. So it's, again, a business decision the generics will have to make about whether or not they want to market at risk. So the patents really, even though the claims are very narrow, they serve the purpose of a tool in this big chess game that's going on. And that's really what patents in the pharma world are doing anymore. The narrow claims, in fact, are more likely to survive an inter-parties review proceeding. They're going to be more difficult to challenge in a court of law, although the Eastern District knocked out these narrow Allergan claims. But narrow claims are very important. So when you hear talk about, oh, these claims are narrow, these claims are broad, really you want both types of claims in your patent portfolio, and narrow claims are hugely beneficial, particularly if they're Orange Book listable. Okay. I think everything on this slide I just have reiterated here, that the patents are really important after the regulatory exclusivity period ends, and that the Orange Book listed patents, those that cover the drug product, the drug substance, or the method of treatment, those are eligible for listing in the Orange Book, and they're very valuable for the reasons that we've seen here. So when you're thinking about patent claims in a patent portfolio, narrow claims are good. Method claims that are narrowly tied to the product and the formulation, also valuable. Lots of dependent claims become important to have in some of the patents that are listed in the Orange Book, because in order to invalidate the patent, the challengers have to knock out all those dependent claims and find prior art against every single dependent claim. And there's a fee attached with how many claims you can challenge in an IPR, and the more claims, the more expensive it is. So there's also a bit of a financial reason to have lots of dependent claims to try and make it expensive for challengers to challenge your patents. And the approach that Allergan took of, they had 6 patents covering a single product. A picket fence approach also is a more financially insurmountable burden to challengers. So with that, we are ending on Valentine's Day at 7:23. I'm happy to take any questions that you have. Thank you. Yeah, they did that in September of 2017. The St. Regis Mohawk tribe was joined as a party to both the lawsuit and to the proceeding at the USPTO. So yes, it does impact standing, and no doubt this was discussed with the St. Regis Mohawk tribe, and they fully understood that they'd be acquiring these patents in addition to being named in some lawsuits, probably worth $15 million though. Yeah. I might do that for $15 million. Any other questions? Hi. Yes, yes. So I think there's probably a box at the patent office that's down in the basement that has all the provisionals that never see the light of day, right? It's online, yes. It's an online dark server. And yes, provisionals, some companies do that. I have some clients that will file a provisional, and a year later, they're still not sure if they're going to move forward with the project. And my question is, have you publicly disclosed the idea anywhere? If you haven't, then yes, it's okay to, refile the provisional, realizing that we're a first to file country now, and that someone else may file before you. And if you understand those risks, yes, the provisional can be refiled, and you set a new one-year date. Hi. Yeah, so it's all in the contract that's drawn up between the parties. So in this case, Allergan transferred ownership. It's like you selling your house to your neighbor, but renting it back. That's exactly what happened. Allergan sold their patents to the Mohawk tribe, but then rented back the right to use those patents in these lawsuits and to protect the product. In other cases, you can just sell your IP and sell all the rights associated with that. A lot of people like to think of intellectual property patents as a bundle of rights. It's the right to make, use, sell, offer to sell, and you can parse those out. You can license to someone just the right to make, someone else the right to use. So you can contractually do lots of good things with patents. Okay. Yes. So in an inter partes review proceeding, some of the claims may survive that reinspection by the patent office. You know, some of them maybe go down. It's unlikely that the party can amend the claims to try and save them. But certainly the judges that look at the claims may decide, okay, some of these are still patentable, some of them are not. And the patent would be reissued with an indication of just that finding. I suspected it was a novelty issue, that sort of language, because you're right. It's hard to imagine an argument for patentability if the prior art had 2 peptides and then Allergan was trying to argue that our composition is only 1 and it's not obvious to remove 1. Unless the 2 peptides in the prior art acted synergistically and both were needed, then maybe that would be an argument. But it could be that there was some strange piece of prior art that happened to have 2 peptides. I'm not even sure what peptide is in the cyclosporin formulation because cyclosporin is not a peptide. Were any of the other components in there a peptide? Oh, it's a cyclic peptide. Okay. Yeah, so some prior art had 2 peptides. See, you can go on Pear and read all about it. Hi. Good questions, good questions. I'll take the second one because I can remember it, and then you'll have to remind me of the first one. So the second question is the agreement between Allergan and the St. Regis Mohawk tribe no doubt prevented the St. Regis Mohawk tribe from doing just what you proposed.